Hi there. Do you want to transfer data? Well, let's take a look at the regulatory landscape because you'll have to make some choices based on the resources, time, skill, or any limitations of your specific data transfer scenario. Welcome back to the Privacy PowerUp series. I'm Noël Luke and Chief Assurance Officer at TrustArc. Before we start looking at what laws prohibit or restrict, the first step is to figure out what is a data transfer. It may not be as straightforward as you expect. While our discussion is not limited to GDPR or a specific region, what I'm about to share is a good example of what you might encounter. In the EU, the GDPR doesn't define what constitutes a data transfer, so the European Data Protection Board issued some guidance. Let me read a snippet of that for you. Paragraph 16 of that guidance. Some examples of how personal data could be made available are by creating an account, granting access rights to an existing account, confirming, accepting an effective request for remote access, embedding a hard drive, or submitting a password to a file. It should be kept in mind that remote access from a third country and or storage in a cloud situated outside the EEA offered by a service provider is also considered to be a transfer, even if it takes place only by means of displaying personal data on a screen, for example, in support situations, troubleshooting, or for administrative purposes. So, if you're not sure if something is a transfer, here are some questions or actions to take that might help to figure out if it is a transfer. First, map out the data. Where did you get it from? Where is it stored? Who accesses that data? Who does that data get shared with? And where are those parties accessing that data? Once you start to answer these questions, you can then begin to use guidance like that provided by the EDPB to figure out if your data movement, data flow is a transfer. Great. Now that we've covered that, let's move on to the topic of when we can transfer data and how. More and more countries have data privacy laws, and there is a range of perspectives on the restriction or permissibility of transferring data. On one end of this range, you have countries that have no data transfer restrictions. A lack of restriction at this stage is most likely because there isn't a privacy law in place in that region or a privacy law at a national level. Until very recently, the United States had no restrictions. On the other end of the spectrum are what are known as data localization laws. Those laws can be data residency requirements, meaning data generated in a certain region must be stored in that region. Other times it could mean a complete restriction on a type of data. Some countries with data localization requirements include China, Russia, and Vietnam. Now, let's talk about the transfer restrictions or permissions that fall somewhere in the middle range of no restriction to prohibition. Let's start with the concept of adequacy. An adequacy decision is when one country deems the privacy laws of another country adequate enough to protect the data, and a transfer is then allowed to that region. According to one statistic, there are over 80 countries or jurisdictions that have some kind of adequacy scheme in their data protection law. Here are some examples of adequacy. So data transfers from the EU to Canada. Canada is an adequate country based on the privacy regulations that exist in Canada. So data transfers can happen without additional effort. The EU-US Data Privacy Framework is a type of limited adequacy. It grants companies that certify to the Data Privacy Framework the ability to transfer data from the EU to the US. A couple more examples. Japan and the EU have mutual adequacy, so they have deemed each other's laws, providing adequate enough protection to transfer between those two regions. The Dubai International Financial Center, which is an economic area, has found that the APEC cross-border privacy rules system is an adequate transfer mechanism. Let's talk now about transfer contracts. These are most often known as standard contractual clauses, or in some cases, model contractual clauses, and different regions may have different names. For example, the United Kingdom refers to their version of these contracts as the International Data Transfer Agreements, or IDTAs. So, how do you use a standard contractual clause? The title's self-explanatory. They're standard clauses, meaning they're templated. They don't change, they aren't negotiated, and are required to be agreed to as drafted. And they're contractual clauses between the parties transferring data. In this scenario, you'll need to figure out who is the data exporter and who is the data importer. In some instances, you may need to identify what your role is with respect to the data as a data controller or a data processor, because that may help you to decide which version of SCCs, standard contractual clauses, to use. There are around 20 plus different countries or regions that have these types of transfer contracts as a means of transferring data. Here's some examples. So you have the EU standard contractual clauses, or SCCs. We talked about the UK IDTA. They have a version. Other regions that have SCCs include China, Hong Kong, Brazil. So SCCs are contracts, so they must be executed by the relevant parties. You'll still have some areas to complete, providing information about the transfers themselves, however. These can be both a convenient method for data transfer in some situations, and in other situations can be quite burdensome because you're implementing them on a transfer by transfer basis. Let's talk about consent. Transferring data across borders based on consent means that the individual whose data you are transferring has consented to the transfer. Now, if you collected consent for the collection of the data or the processing of that personal data, that does not necessarily mean you automatically have transfer consent. You'll need to get that specifically. Depending on the region you're transferring out of, there may be different requirements for what consent must look like, what attributes it must have. Some other methods for transfer: there are allowable derogations that allow one-time transfers in different situations for the performance of a contract, vital interests of parties, legitimate interest, etc. The EU, there's another method, also has what is called BCRs, which are binding corporate rules. And that is a way for large multinational companies to transfer data within their organization, but across international borders. So it's an internal transfer within an organization, but still across borders. And under the BCR, there is a set of rules in place that organization adheres to. That's the binding corporate rules. Then there is the APEC cross-border privacy rule system, and the new global CBPR, cross-border privacy rules forum, which grew out of the APEC system. And that framework is an international privacy framework and system that countries sign on to. And under that system, a company that certifies that their practices meet the requirements of that voluntary approved framework, then they can transfer data between all the jurisdictions or economies that have signed on. So in the case of the APEC system or global CBPR forum, that's countries like Japan, Korea, all of North America, Australia, and some other regions as well. So you can transfer between all those different regions. To wrap up, you've got to map your data, know where it's going, where it came from, where it's stored, who has access to it. And then once you have the answers to those things, you can maybe start to look at these different methods to see what is the best transfer method for your organization. Maybe it's BCRs because most of your transfers are internal or you're a big organization. Maybe it's SCCs because that really works, the relationships you have. Or maybe using something like the data privacy framework and getting certified to that once a year is an easier method. So these are all the options that you can look at to decide what's the best data transfer method for you. That's all for this segment of the Privacy PowerUp series. If you haven't already, go back and watch the previous videos in the series that cover these topics. Getting started in privacy, data collection, minimization, retention, deletion, necessity. There's some on data inventories, mapping, and records of process, individual rights, data subject rights, privacy contracting, and choice and consent. And next up to help you power up is new and emerging technologies. Thank you for watching.